Hello everybody, this video is going to act as a checklist and also just an update and feedback on looking at drafts for the assignment this semester. So these are just comments that come out of discussions and the notes. So the first comment I'd make is just about AI. As I've said many times, it's a good tool, but take care of it, care with it I should say. So write your answers and allow it to critique your answers is a good way to start with this rather than asking it for an answer. Ask it to explain the areas if you're not clear from the notes. Ask it to review what you write, and then you can start to argue with it. But one thing I'd suggest you definitely do is tell it to be the same as a lecturer would be marking a year one degree paper, because it stops with its algorithm to tell you that everything you do is excellent, perfect, great idea, which no doubt you've noticed in its answers, and that's how it's set up. That is not very helpful for you in terms of using it as a learning tool. So tell it to stop being nice. Take care with cases if you use it. I'm seeing too many cases in assignment drafts and they are not necessary. And some of them are simply non-existent. The same thing's happening with articles. You really don't need cases and you don't really need articles for these assignments and these law papers. So argue with it. If, for example, what if I, and just put something in, or when would your answer be wrong? It's a good way to approach it. Tell it what you do, for example, in your own life, and ask for an applicable example that helps with applied understanding of the application of these areas. And simply disagree on points. Just say, no, you're wrong. Tell me why you're right. And give it your own examples and then argue with it. Even if you're arguing something wrong, it's just a very good way to get different perspectives. But using it to simply cut and paste or at least give you a series of statements to make, it tends to be fairly obvious, but the problem is it's quite inaccurate at times. For example, you see terminology. Instead of saying enforcing security, it's run after the person. It's a very common AI phrase when it's trying to make it look like it's human authored. So, as said before, people are using it quite legitimately, and it's going to produce phrases, and you may like to use those phrases, but just take care with that. Now, that aside, your business, a couple of people asked about businesses and seem to be just putting too much effort into the business. Any business is fine. It's simply to give you a reference point that you're comfortable with instead of me setting questions which are inevitably going to be about something which you may not find particularly interesting or relevant, or if you're familiar with, so you spend too much time working out the facts, whereas if you use something that you're familiar with, it means you're applying the law, and that's a far better way to learn than it is to try to understand facts somebody else provides all the time. So just anything will do. I don't mean totally anything, but some form of business that has goods or services. Now turning to what I'm seeing in the actual drafts, which mostly are pretty good, the starting point here with this first part, too much effort going into this actually. Look at the marks, they're not very many. So what should you be doing? Start with definitions, offer, acceptance, invitation to treat. You have it in the notes, you can get explanations of it. And then you're going to compare with your conversations with definitions. So when you write a statement and you're saying it's an offer, then you should be saying, well, does this match the definition of offer? Statement of terms, intention. When you're looking at answers to prospective clients, you're trying to draft something which is not an offer and not an acceptance. So in which case, a question is posed by a client, whatever it is, and you're simply answering that specific question, trying to get some business from them, but not committing yourself to it. It's very easy for those answers to actually be offers, which is why you need to be thinking, what's my definition of an offer, a statement of terms and intention? Why is this answer not an offer? An invitation to treat's very much the same thing. You have the issue of what is it, and we've been through that many times in the notes, and your example should simply be an invitation to treat and point out what's missing from the definition of an offer. Most advertisements, of course, are invitations to treat, and it does require a very clear intention to be bound to anybody whatsoever who responds, which is very rare. And the third one's an offer, and that's really straightforward, but again, it's just definitions. Now, the focus here is your facts. So setting out the law and then just moving on is not going to get you many marks. At best, it gets halfway. So I'm seeing quite a bit of law explained with very little application to your own facts. So write your statement, say why it's an offer and what its legal effect is, because this does say a communication that illustrates applying the law. Now the second one here is very much the same. Client makes an offer to you from the invitation street, so make sure you put down the offer. Seeing drafts that don't have an offer in there but launch straight into the answers to it, it was very hard to say, well, was it right when there's no offer to compare it to? So this is a communication, and it's simply asking you for more information. So again, what you're trying to do with this is not answer as a counteroffer, not off answer as a rejection, and keep it open for you. You're just asking questions, so you don't go too far with it. And again, you just refer it back to the definition of, is it an offer or is it an acceptance? No, because of the way you've written it and why it doesn't meet those definitions. Change the offer, that's counteroffer, of course. This has pretty much been very well done. So you need to say why it's a counteroffer, what is it changing, and therefore its effect on the offer and its current effect, which is, of course, the and the notes and the extinguishment and the creation of new offers. And so that creates the legal implications. So when you talk about legal implications, bring it back to your business. So what are the practical implications of this for me? 3 marks is only a paragraph. Definition, example, and how does it affect you in a business? And rejection is another option. It's really, these are following through what are your options in a business situation. Do I want to just know more information but not get committed? Do I want to actually get the business but not on the terms offered? So I'm going to counteroffer. And do I just not want it? I'm going to reject it. And that's going to free me up. So the same thing applies here. What's a rejection? Make it a simple one. Don't overcomplicate it. What's the effect on the offer that's made? And don't forget that last part. If you rejected it, what's the effect on you and the other party in terms of what are you free to do? And does it give you some certainty? Remembering all this is about certainty. So you don't really need many lines in this. It's pretty straightforward. So make sure you've ticked off those requirements. Terms of the contract, again, pretty well done on the first one. It's obvious, just draft any one express term of the contract. Express as what you've agreed openly or explicitly. Define that. So those are the definitions. Make sure you define it and just put it down as your example. So that's very straightforward. This one here is causing a few problems because sometimes it's implied terms that it's fit for purpose, which is a statutory implied term. So don't use something like that. Now, the example I've got down here is I build trailers and sell to the public. That's the longer videos, which are there as a deeper backup if you want to go deep into these things. But this is meant to be a checklist as a basic overview in terms of what's necessary to pass. So I build trailers, and I cannot use fit for purpose because it's in the CGA or the CCLA if it's a business situation. So what can I use? Just a quick example. If I've to do a paint color, I said it'll be a blue color. Well, what's blue? So it's not decided what is blue. We didn't have a sample. It's just blue. And so if I'm painting a trailer, it's going to be implied it's blue trailer paint. Paint that's appropriate for trailers and the typical colors that go with it. So the client might say, oh, it's not bright enough, and say we really wanted bright blue, deep azure type colors. Well, it's not an express term, so therefore what's the implied term? Well, it's going to be whatever's normal on a trailer or acceptable. And so that's not a fitness for purpose or merchantable quality. It's just a straight out what would most people expect to give it business efficacy, because it has to be workable in business. So don't forget to define that business efficacy. The term efficacy just means workability. It's about practicality. Then when you get onto the third one, point I made here is don't argue too much on a 5-mark question. And implied terms, well, use, if you're a service provider, use the FTA or the CGA for services, not goods. So I am seeing what are clearly service provisions, but being argued under the provisions for goods under the Consumer Guarantees Act. So you've got the Consumer Guarantees Act and it's clearly got services. The electronic exchange contract, this is pretty straightforward, and there's some good notes on it. If you go to the, obviously into the canvas, follow through to content for each learning outcome, there's a whole lot of notes there which are laid out and matched up to the tasks. So you've got all those sections. They're not necessarily working through all of them, but there are key ones, particularly 214 and 217, which is communication of acceptance of offer, which is the formation of a contract. So of course that's key. But then you've got when it's sent and when it's received and how this changed. So if you don't agree, you use these rules, and it's all about when you send and receive them. So this was just about the notes as to why it's different to normal contract area. But in the assignment, you're really just going through the relevant sections from 214 to 217, and it's useful just to briefly explain those sections and then come back to what's actually asked here, which is two parties in different countries, and the question is, when is there a contract and where are they? So the key things in here are that we have a contract done by our email, which means electronic, therefore you have to talk about the information system. Now perhaps people seem maybe a little bit confused as to what that is. When it says the enters or leaves an information system, it doesn't necessarily mean your computer in front of you. On email, it would mean leaving the email system. So if I email you on Gmail and I use Outlook on my computer and I go send, it goes to Gmail. At that point, it's still theoretically within my control. I could delay send, for example, but it's then going to leave Gmail servers and go to the other person's, say Hotmail, and hit their servers. So when it leaves Gmail, it's sent. When it's received into Hotmail, it's received, regardless of whether the person's got it or not. That's the issue with these electronic systems. So then the question is, when do they get it? And of course, those sections tell us when they get it, and then it tells us where they are. And that's important because it determines whose law applies. So you've simply got those two issues. When's the contract formed and where are the people? So just follow through that. You can follow through on the guide that's on here, following through the sections. But basically, it's just follow through those main sections, and here's a table for it. And so you can work out when you actually have a contract form, which is 217 primarily. So work that through and just apply it. Now you're actually using given facts here, so you don't need to worry too much about your own business here. This one here seems to be no problems. On the class notes, there's an example of an MOU, and a memorandum of understanding is itself a agreement, but not a contract. Quite often they are a contract for specific things like confidentiality, but we're not doing that here. We're just drafting a memorandum of understanding to negate the intention to create a contract. So what's the best way to deal with this is simply to set out the law and intentions. So if you go to the notes on Canvas again under content for LO2 and you go through there, there's a summation of all these. So get an understanding of that, the intention issue and the test for rebutting it. So it's a presumption, something is true unless it's proven false, and the process of proving it false is rebutting. And in commercial situations, you have, of course, the issue of presumption of contract, and you rebut that by words that say there isn't intention, hence you use the MOU clause. So the law is really straightforward. The key here is your facts. So set out why you'd want to do this, why it's important not to. And when we talk about a joint venture, we just mean two people working together or two companies working together. And so all businesses can form a joint venture, which is simply working with each other, something that you normally can't do alone. It's easier together. So expanding your business to another location, that would be a good example. Instead of you setting up a new business in another city, you might do a joint venture with somebody else where they are going to set it up and you're going to share the revenue. And that would be quite a complex negotiation. It's a very typical one where an MOU is used. Or you might be deciding to buy another business and you want to make an offer to see if they are likely to accept it, but you don't want to be bound by it. So you write an offer, what would normally be a complete offer to buy, and you say, this offer is intended to be used only for negotiation and shall not form any contract. And then you've taken away the intention to contract. So the real issue with this isn't the law, it's straightforward, but it's just thinking through the facts and applying it. And do that throughout the assignment, not in great detail. Again, 5 marks, not a lot. The consideration questions are pretty well done, but define consideration. What is it? It's something of value that's necessary to form a binding contract. So when you form a contract, there must be consideration. When you vary a contract, there must be consideration. Now, there are exceptions, and the exception for the last odd mark or so is promissory estoppel, which you talked about, and that's based in equity, not in not in common law. But the main part of this is just defining consideration. When's it necessary? What if you have it? What if you don't have it? Because you don't have it, you don't have agreement to change the contract. And then you're talking about what effect does it have on the contract. So when we do that, of course, we have basically a variation. So make sure you follow that through. Misrepresentation is really just follow through on the worksheet. It's a pretty straightforward area. It's 8 marks though, so you really need to follow through the key things. And that worksheet is sitting there for you, and we have to follow through on these steps. So your misrepresentation could be whatever you like. It can be a straight out fact that's not true, that's not a term of the contract. It could be your opinion. That's quite a nice one to do because you can give your opinion, and then you could potentially be sued because you're an expert and your opinion was wrong. Easy. Right? So these ones, intention and silence, are a bit trickier, but the notes are there if you wish to use those. But the question just says a misrepresentation, and it can't be a term of the contract, so it's some statements you make, you don't end up in the contract. Now, it'd be very easy to actually write something which is possibly implied, but I'm not going to be very harsh on that. But just try and write something which wouldn't be a term of the contract. And if you're confused by that, you can just make an assumption that this will not be a term of the contract. Therefore, it can only be sued on if it's a misrepresentation. You only need one. So you don't need to write through on everything here. It's just one. So once you've decided this is a misrepresentation, then you're just turning through on the effect. So you can define it. Is it a misrepresentation? Is here. You just have to be able to show it's wrong. It has to be a fact and it has to be provable wrong. A fact is something which can be objectively proven. So for example, if I say to you, this engine is in good condition, in my opinion, well, it's an opinion, but it's also a statement of a fact because a engine's condition can be proven by a mechanic to be in good condition or not good condition. There's obviously a shady area in the middle of that. But if I was to say, oh, this car's only done low mileage, and then you find out it's actually done high mileage, clearly I made a statement of fact and it was wrong. That's a misrepresentation. Once you've decided that, you just jump straight into the sections, the remedies, and you're just going to go into the Contract and Commercial Law Act and pick the right sections. As said, you can write Contract and Commercial Law Act once, put CLCA thereafter. In the test, definitely do that in the third test. And just go through and find the right sections. Here it's this area of damages of misrepresentation. So for this remedies, you need damages for misrepresentation, which is, of course, going through what's necessary for it, which is showing inducement. Well, it's taking forever to load, which is very typical. And then cancellation, which is 37. So you need to be working through 35 and 37. And you can't cancel if it's affirmed. Has it got there? Yeah, it has. So key thing is to induced, and you just need to show on your facts why you might be induced. So induced is caused. It doesn't have to be the only cause, but it must be something that caused the person to contract. In other words, it was something that they relied on. It was maybe somewhat important to them. At least it was a factor in the decision. When it comes to cancellation in this area, then it has to be much more serious than that. So cancellation comes under section 37. So that's down here. So I didn't put the actual sections in here, although I think we did when we were talking through it. But that's section 37. And in 37, you have to work through the question of whether, just go through to it. That's repudiation. We'll be talking about that very shortly. So if you've been induced in the misrepresentation and the effect will be substantial, then the person can cancel. Straightforward. And then the person can claim damages. Now we've only talked about to that point, so you can actually stop at that point. We will take it a little bit further in the next section, but only to one more section. So follow through on the misrep, just following the table. Minus contracts. Again, it's very much the same thing. It's pretty straightforward, minus contracts. So go to the sheet. You've got the sections set out there and a worksheet to follow through. So just make sure you tick off the relevant sections. And in your particular example in the assignment, you're finding a situation where your contract would be unenforceable, meaning it doesn't meet the requirements of Section 90 when the court works through it. So one of the problems I've seen in a few drafts is seeing the Miners Contracts Act 1969 term up. I've actually seen something called a Misrepresentation Act somewhere or other. There's no such thing. This act was repealed in 2017. It's AI just picks it up all the time and decides to tell you that's the law. It is actually the law. It didn't change, but you can't use a 1969 act. It's in the 2017 Act, the Contract Commercial Law, the CCLA. Keep using the wrong acronym, but I'm sure you know what I mean. And then just follow through on the worksheet. Make sure you focus a lot on the factors and applying them to your example to show why you think it could be unenforceable. And when you look at these sections, this is the practical one. How does the court decide? So you go to section 90 and you just go through the factors and say, well, where are they? What's the court going to use to decide whether this is actually reasonable or not? So they're going to look at the circumstances. Was it all disclosed? Was it fair? How complicated is it? The value of it, and the age of the person. So we know they're 17 in the example. So they're relatively young. And then any other circumstances. If you pressure them or something like that, it's obviously not fair. But the circumstances is really how it was arranged, how much pressure, for example, went on the person, or properly explain to them. Anything that's of significant value and difficulty is going to be a problem. And the court's very likely to say, okay, it's not fair when working out whether it's fair and reasonable, which is what they're trying to do. Courts inquire into fair and reasonableness. And if it's fair and reasonable, you've got one bunch of rules. And then if it's not fair and reasonable, you've got another bunch of rules, which are just the remedies of the court. So you just point out these are what the court could do and what they'll probably do. And then if the miner's done some damage, then you really should be looking at section 95, which is a compensation or restitution. And you are, because that's what's in the question. It's done some damage. Should the miner have to pay for the damage they've done? So make sure you do focus on those sections, particularly on section 90, but also 95, because that will give you the understanding of what will actually happen in these circumstances. Restraint of trade. What am I finding here? Clauses look fine, actually. Make sure they tick off on the various parts required for this. So if I go back to restraint of trade, we had a worksheet here and some examples. So you've got to think about these: time, activities, distance, population, area. But the key thing with restraint of trade is you're protecting something like your clients or your trade secrets. So when you're saying, is it reasonable, you're trying to say, I wrote it to be long enough, big enough area, population, so that the person who worked for me and left is not going to take my clients. That's what you're trying to do. So you're just saying, have I written something time-wise that's reasonable? Am I only covering what I employed them to do or where they could affect my clients? How far will my clients drive or whatever else? The more population density, the less people drive, and the more likely they are to focus on someone else. But as long as you argue these things, I'm not going to argue with you. If your argument's reasonable and logical, and I totally disagree with you, it doesn't matter. It's an application of the legal process that's being marked, not whether I agree with you or not. So definitely do not take that approach. Now, when you've done that and decided it's enforceable and you justify it using those tests, make sure you do so in relation to the business, as I've said, any goodwill or secrets. And you can also note the legislation, which is only that one section, section 83, that the court can fix it up and make it reasonable. They don't want to do that, so it's a bad thing to rely on. So again, just follow through the steps, but focus the practical side of why do you think yours is reasonable in terms of protecting your right to keep your clients and not have your employee leave and take them with them, because that's your goodwill. Now, that's what's following through the contract side of it, which generally speaking is not looking too bad at all. But take note of those, and I think some answers are just being overdone. People have too much work into them. So in the negligence area, this seems a bit tricky at times. So what are we actually looking for here? And the answer is it's just a bunch of facts that you can apply the negligence to. So you need these facts so that you can discuss it. Now, anything's fine, but you're making up the facts. And note, it's the person you cause loss to is not your customer, because you have a contract with them. You know, if I have contracted to advise my client, and this is the negligent misstatement, it was the same issues. If I've contracted to advise my client on some engineering thing on how to build a bridge, and I give them very bad advice and the bridge falls down, they can sue me, all right, but it's under contract because I had a contract to work for them. And I breached the contract by not giving them reasonable advice. Now, that's no problem. But what about somebody else who drives on that bridge in their truck? And let's say they're a beekeeper and they've got all their bees on the back of a truck and they're driving over a bridge on a farm and the bridge collapses in their truck and all the bees go into the river. And so they want to sue me. Well, did I owe a duty of care to those people? Well, were they foreseeable is what we look at here. And the answer is yes, because they're bridge users. Easy. So I owe them a duty of care. Okay, so that's loss or damage to property. Income, well, the bees went in the river, so they can't make any money, so they've lost their income resulting from the action. Personal injury, well, they got hurt in the truck going down, but that's going to be ACC, which is why you've got it in here. And stress, well, it could be really stressful, and as a result, the person driving the bee truck ended up not being able to pay their mortgage, and that was really stressful for them, and it affected their relationship, their marriage. They get a divorce. You know, there could be all sorts of things in there. You can write whatever you like there. It's really just simply about understanding how far you can claim losses. So just follow through those lines, but keep it relatively brief. It's 4 marks, but it's there to set up the rest of the question. I just gave an example here of plumbers flooding and making a mistake on the client's property's contract, floods a neighbour's shop, and that's, do that for me, that's negligence, and they can't control, so that's loss of income, and someone broke their arm, so that's a injury, and they got stressed up for personal problems, whatever we like for that, amuse yourself if you want, and then you've got the 4 areas. So you can see how this flows through. The mistake is contract, but the neighbour's effect is going to be negligence. That affects their income, that some injury occurred, and they got all stressed up about it. So what are we doing with these? So this was highlighted, so just change it to green. You can answer these two together, 12 and 8 marks. You can do them as one single question if you wish to. If you're confident, do that. Otherwise, break it out. Now, why can you do them together? It's because when you run through all steps of negligence, you'll go through duty of care, breach of the duty, so duty of care and foreseeability, then breach of the duty of care by deciding what the standard of care required was and that the person didn't meet it, which would be the test of the reasonable person who should have been doing that role. And then you got breach. Then you go to causation. You should be using the real and effective cause test, not the but-for test, which is quite an old one. And then you get into remoteness, where you can recover any losses which are of a kind reasonably foreseeable. Now, when you go through that and apply it to your example, you can decide if the person's going to recover some of their losses. But you don't need to go through these in detail at that point. You're just saying, here's the test. And if you, for example, just focused on that one, at that point, that's just fine. But that's when it moves into the second question, where you can actually just flow straight into the second one. And in this one, where it is, for the 8 marks, you're just applying that test of remoteness in depth to all of those losses you've found. So it's the wagon mound case, which is in the notes, which talks about reasonable, means has to be losses which are of a kind or a type or a class, which is reasonably foreseeable. And for example, if I'm doing some work with machinery, say I'm driving a digger again, and I'm swinging the digger around and I hit a power line with my digger, and the power line comes down and all the electricity sparking all over the place. Now, you could probably foresee that cause a fire. That could cause a fire quite easily. So there's a fire. The fire burns a close by building, and in the building, because it's an industrial area, are some chemicals, and the chemicals explode. And it's the explosion that damages the McDonald's and blows it apart. We'll make it at night so we don't hurt anybody. And McDonald's gets all blown up. And you'd say, well, what losses are foreseeable? Well, you hit a power line and bringing down the power, loss of electricity, losses to people who can't use their power, factories shutting down, fires are certainly predictable. What about explosions? Well, fire and explosion are the same kind of thing. Now, if you were arguing it wasn't, that's just fine. We're not going to get technical on this. But fire and explosion are very much the same thing. Explosions are simply very fast fires, in effect. They're a combustion. And so you might say, well, the same kind of thing. Therefore, if you start a fire and there's damage by something exploding as a result of the fire, then the person who suffers loss from that can claim it. So you go through in depth that test in the wagon mount, and then you simply apply it to those 4 areas. Now, this is where you've got to think about things like ACC and personal injury and remoteness and predictability. And it's a tricky one, this. If we were doing the contracts, for example, with weddings and with a photographer, and I mess up the photography, then what losses? Well, loss of enjoyment and stress is very, very predictable because that's the purpose of taking the photos. So in those circumstances, you could potentially get compensation. Personal injury, if you read through the ACC Act, you'll find, and particularly if you read some articles or AI picks up this for you, is that you can actually get damages for personal injury in New Zealand, but they are only exemplary damages. So you can't get, for example, damages meaning money, of course. You can't get damages for a broken arm or your loss of income from a broken arm. But if the person who broke your arm, for example, you were standing on the side of the road and I'm driving a digger and I've tied something to it and I'm just spinning the digger around and around and around, then releasing this thing because I'm having fun and trying to play some stupid game and I hit you, that is so reckless that the court might decide to punish me by making me pay exemplary damage, just to make an example of me, and you may get some damages. That is the only case where you're likely to get damages for personal injury. So when you're reading through it, if that comes up, just be careful with that and stick to the basics of the ACC Act. So the game here is the purpose, I should say, is really to just go to the accident compensation provisions and get an understanding of what you can sue and what you can't sue for. Because it's very much, if you're not the case in New Zealand, and if you're not from New Zealand and you're in a country, which is just about every other country, where you can sue people for personal injury and say car accidents, this is a very strange thing. New Zealand's one of the very few countries where you can't sue. For example, you run into the back of someone in Australia or America, there's a good chance they get whiplash of the neck, and the claim for damages is very high. Okay. So that's basic. Follow through all the steps in the sheets because there's all this is set out in the worksheets for you. So follow through all this sort of stuff. And then going on to the next bit is this whole vicarious liability thing. And that's pretty straightforward. But again, it's your application of the facts that's quite important here. So you've got two situations here. One is liability for your employee, and one is, do you have liability for your contractors who are not your employee? And so we've been through that, and you can work through the issues of the tests of when you're liable, which is in the notes. You don't need to worry about the examples like Partnership Act, which creates this outside of normal common law principles. Just stick to the basic principles. So I gave 2 examples from cases I had. They didn't go to court, they were just situations I had, I should say, probably. When being in-house solicitor for a company at the time. So the 2 of them were car parking, and valets crashed cars when they were parking them. One of them did it on site by crashing the side of the car into the sides of the entrance to a garage underground under the hotel, one of the major ones in the middle of Auckland. And that, of course, was part of the employment. The other one just went for a joyride down the motorway and totaled the car and a couple others. wrecked it, I should say, and the hotel wasn't liable because it just went too far outside. So you can see from that you're not always liable for employees, but the courts are more likely to hold an employer liable for employee actions during employment time than not. So it has to be something quite extreme to go outside of it. Now, in the contract one, I just make a note here to see, just to make you aware of this. Some people are saying you can be liable, as people are saying, for selection of the contractor, and that's true. If you don't do proper due diligence on your contractors and you employed somebody to do some work who was utterly incompetent, you really should not have, you can be liable, but that's actually negligence on your part. It's not really about becoming vicariously liable for the actions of your employees. That comes down to more to your control. So really, if you treat people like employees, the law can make you liable for them. If you don't, then they can be independent contractors. But if you employ people, you are likely to be liable for their actions. Okay, now that's enough for this one because I want to keep them short, and I'll do another one for the part 3 and part 4. So that's it for now. Thank you.